On May 8th, 2020, changes were made to the Utah Administrative Code that impact policy and procedures for child care providers accepting subsidy payments from the Department of Workforce Services. Many of the changes were made in response to audit recommendations to strengthen the integrity of how the subsidy funds are administered and collected. These changes include updates to the disqualification rules to allow for more flexibility and to ensure that a fair process is used when making the decision to disqualify a provider from receiving child care funds. Although we cannot address all potential scenarios in this training, this webinar will provide a general overview of the changes and cover the following topics: overpayments, disqualifications, monthly certification, Department of Workforce Services Provider Guide, the electronic W-9 form, and cooperation with audits and investigations authorized by Workforce Services. Overpayments. For all provider overpayments with an order of default notice dated on or after May 8th, 2020, the overpayment must be repaid in full within 30 days, or a repayment plan must be established with Workforce Services and kept current. For all provider overpayments with an order of default notice dated before May 8th, 2020, the overpayment must be paid in full by the due date, or the already existing repayment plan must be kept current with Workforce Services. Previously, when an overpayment was not paid in full by the due date, or repayment arrangements were not kept current, the provider would be removed from the Workforce Services approved provider list. Parents would be notified of ineligibility, and the provider would no longer be eligible for subsidy payments until the payment was received. Under the new rules, when an overpayment is not repaid by the deadline, or a repayment plan is either not negotiated or kept current, all future subsidy payments may be withheld from the provider until the payment is received. The provider will remain on the Workforce Services approved provider list, and the parents will remain eligible to stay with the provider. A provider shall not charge Workforce Services families for a withheld child care payment. Additionally, the provider will not receive further subsidy payments until the required payment is received. Once the overpayment unit receives the required payment, any subsidy funds that were put on hold will be released to the provider. The funds will be issued and made available following standard direct deposit procedures and timeframes. For providers receiving a high-quality enhanced subsidy grant, rather than withholding payment, the overpayment will be deducted from the enhanced subsidy grant each month until the debt is paid in full. The overpayment may result in the department filing an administrative order with the court and pursuing a lien for collecting the overpayment. A lien is a claim against assets to satisfy a debt. Penalties for fraud. Workforce Services refers to fraud as an intentional program violation. When a provider commits fraud or an intentional program violation, a 50% civil money penalty will be assessed and must be paid in addition to the amount of the overpayment. Disqualifications. A provider may be disqualified for an intentional program violation. An administrative disqualification hearing will be held prior to making that determination. The hearing will be held with an administrative law judge who will determine whether the provider should be disqualified from the child care program for committing an intentional program violation. A provider may be disqualified for reasons other than intentional program violation. An administrative disqualification hearing will always be held before disqualifying a child care provider. If the administrative law judge agrees that the provider should be disqualified, the provider will be disqualified for a certain length of time. The disqualification time periods are 1 year for the first disqualification, 2 years for the second disqualification, and lifetime for the third disqualification. Any overpayments, including civil money penalties, must be repaid in full before the disqualification can be lifted, even if the time period has ended. During the disqualification period, Disqualified providers are not eligible to receive any type of child care funds from the Office of Child Care. If you would like more information about disqualifications or the administrative disqualification hearing process, please refer to the Utah Administrative Code. In addition to the overpayment and disqualification rules, additional rule changes have been made to the monthly certification requirements, agreeing to the terms and conditions of the Workforce Services Provider Guide when substantive changes are made, requiring the completion of the electronic W-9 form, and cooperation with audits. We will give an overview of these changes next. Monthly certification. Licensed providers are expected to complete the monthly certification process in the DWS Provider Portal starting again in October 2020. The certification time period is the 25th through the last calendar day of the month. Certification helps to reduce overpayments by ensuring that cases have been reviewed and required changes have been reported. Under the new rules, certification is expected to be completed every month. Monitoring of attendance records may be required for failing to certify regularly. The Workforce Services Provider Guide. New providers will continue to be required to read and sign the Workforce Services Provider Guide terms and conditions as part of the approval process with child care licensing. This is a requirement in order to receive child care subsidy payments. Providers who already receive subsidy payments will no longer agree to the terms and conditions during their annual licensing renewal. Instead, providers will agree to the terms and conditions each time they log into the Workforce Services Provider Portal. Providers will be notified when substantive changes are made to the provider guide and a new version is available to read. Providers will agree to any changes in the terms and conditions by logging into the DWS Provider Portal within 30 days of the announced changes. Failure to log into the DWS Provider Portal within 30 days of the announced changes may result in subsidy payments being withheld until there is a record of the provider logging into the DWS Provider Portal. The Workforce Services Provider Guide has been updated to reflect the changes to the Utah Administrative Code. An announcement will be made once it is published. The electronic W-9 form. Beginning November 1st, 2020, all providers must complete an electronic W-9 form with child care licensing. This information will be shared with Workforce Services and will be used to issue the 1099s annually. This replaces the requirement to enter a tax identification number in the Workforce Services Provider Portal. The electronic W-9 is secure and will help ensure accurate information is being shared with the Internal Revenue Service. Completing an electronic W-9 form will become part of the licensing application process for new providers and must be completed to accept subsidy payments. Current providers will have until December 31st, 2021 to submit the electronic W-9 form. Workforce Services will continue to issue 1099s for subsidy payments based on the tax identification number reported in the DWS Provider Portal until an electronic Form W-9 is received. Once the form is submitted, it only needs to be updated when there are changes to your business. For current providers who do not submit the electronic W-9 form by December 31st, 2021, subsidy payments may be withheld until the form is submitted through Child Care Licensing's portal. Cooperation with audits and investigations authorized by Workforce Services. Under the new rules, the expectations regarding audits and investigations are more clearly defined. Providers must cooperate with an audit or investigation authorized by Workforce Services, and providers must keep accurate and complete time and attendance records for 3 years. Penalties for non-cooperation or failing to keep accurate records include withholding payment until the provider cooperates and being referred to the overpayment unit and being found liable for an overpayment. Additionally, a provider who fails to cooperate may be recommended for disqualification through the administrative disqualification hearing process. For further information, please see the Utah Administrative Code, section R986-700-730, Audits and Investigations. This webinar has provided an overview of the administrative rule changes. This webinar did not address all potential scenarios covered in the administrative rules. Please review the Utah Administrative Code for more information about these changes. The Utah Administrative Code website is rules.utah.gov. This website is in process of being updated, and as of the date this webinar was recorded, the changes were not yet reflected. Each provider should have received a copy of the changes to the Utah Administrative Code enacted May 8, 2020, as an attachment to the email announcing this webinar. If you have questions about these changes or need assistance with any of the new requirements or changes, please email the Office of Child Care Provider Helpline at occ@utah.gov.